Another strong way to protect trademarks is to include trademark provisions in any kind of agreements. Whether it's an end-user license agreement, a terms of use on a website, an agreement with a company you're doing business with to create a partnership or a new deal. Who owns what? Who's allowed to use what under what circumstances? Who owns any new trademarks that develop as a result of this relationship? All of these types of things, they should be in writing. And a great way to help protect your trademarks, if you haven't done this, tonight, please, create a Google alert. It's free. There's probably other competitors that offer similar services with your product, your main product names in it. Every day, every week, whatever options you choose, they will email you a list of all of the new sites or blogs or news articles that come up with those terms, and you can then evaluate whether or not they're related to you and they're authorized, or whether or not this is some new problem. This is a great way to get free alerts about possibly infringing materials. Protecting your copyrights. As I noted at the beginning, you have rights just when the copyright is created, when it's made public, whether it's a photo or a software code or a PowerPoint presentation. But you greatly enhance the enforceability of those rights if you put the proper copyright notice on there, like you see in this slide. And you would put the copyright symbol, the year it was created, the owner of the copyright, which if you have a corporation, I would use the corporation, and the phrase all rights reserved. And you should use this at the beginning and or the end of all materials. Advertising materials, audio, video, websites, blogs, software for sure on opening screenshots. Yes?
If you're doing business as you're registered, is it better to use your own name or the name of the registered?
Yeah, if you have filed a DBA and you want to keep your own name out of it, you can use the DBA's name for that. That's fine. Yeah. You can register a copyright. Registration is with the Library of Congress. Certainly, a software program, for all of the labor and cost and time that goes into it, I believe it is worth the cost to go ahead and register. The filing fee is only about $50. Unfortunately, it's only good for that exact software code that you submit to the Copyright Office. And that means when you update it, when you have substantial updates, you should refile, re-register. If you have a website that has a huge amount of creative original content on it, you can basically dump the whole website onto a disk and you send them the website and you register the website. I would certainly think about doing this for any software company. And just as in trademarks, even more important for copyrights is including the language in contracts. Because if you have somebody working for you, helping you write content or code, if you do not have it in writing, many people do not realize that by default, a contractor who's not an employee actually owns the work that they're doing. They actually are the sole author or co-author with you of that code. And that can create humongous problems. People pay designers all the time to develop a website. They don't have a contract, or they don't have a good contract. The website designer says, well, I know we quoted you X price originally. It's turned out to be a lot more work. It's now going to cost you twice X for us to finish the project. And you say, well, that's okay. We'll just take what we agreed to originally, and we've already paid you for, and please give us that. Please give us the product. Well, unless you had it in writing, you don't even own the work that they've done so far, and they may not have to give it to you. And they may not give it to you. Also, if you have users who log in, who buy, who operate your software, your website, your online service, your app, whatever it is. You need copyright terms in there. Basically, they're getting some sort of license to use it. They're not getting a license to copy and make 100 copies to give to their friends or to give to every office in their building. They're not allowed to, excerpt portions of it and incorporate it into some other program that they're selling for a profit. All of these things need to be spelled out in writing. You have some rights, even if they're not, but it's far more enforceable if it's in writing. And hopefully most of these things never get to a point where you're litigating them. It's just the fact that you actually have it in writing and have something that's enforceable that will help resolve it a lot quicker. Because if the other side has no case, they're certainly not going to litigate it. Yes?
One step back, I guess, but
okay.
Also related. With regard to registering the $50 fee for things like software or a website, do you get any rights or protection if you've done that one time, but then you continue to modify what's actually being, put up, because that's what we all do.
Well, you have the registered rights only in the scope that was registered. You have the other rights that come with just creating it and just giving the proper notice for all those subsequent modifications. So you have a combination. That's why every year or every significant upgrade, I would recommend that you re-register.
But if you don't re-register, and if you actually have to pursue somebody who's done a complete copy of what you've done, then it really doesn't help to have had that original registration.
It would probably help in the preliminary phase of the dispute, notifying them of it and trying to resolve it without litigation. But to actually litigate it, you would have to go back and try to re-register that updated version on a fast track, which costs more money. And it's still slow because the Copyright Office, believe it or not, they take about 2 years to even open the mail and tell you that they've accepted your application.